Good morning, everyone. Welcome at this panel on the tension between two fundamental rights, 2 out of 3 very important fundamental rights on the internet, freedom of speech and privacy. We have a really interesting lineup. My role is being the chair, and last year I, for the first time, heard about being a silent chair. And at first I said, no, then I'm going to be a moderator. I don't want to be a silent chair. I want to talk. But then Ian Brown was the moderator, and I was just sitting there, a bit laid back, following all the discussions, and I kind of liked it. So that's why I, again, this year am the moderator, the chair, so you won't hear me that much. I will just introduce the speakers, and we'll do some time management. They have 12 minutes for the presentations. I'm here on behalf of SOLV Advocaten, SOLV Attorneys at Law, an Amsterdam company. And that's because otherwise we would have too many people from the Vrije Universiteit Amsterdam. And because I'm affiliated to both, even before I was affiliated to SOLV Advocaten, I could use it. I said, well, no problem, I will come as someone from SOLV Attorneys at Law. So here I am, not from Vrije Universiteit Amsterdam, but as an off-counsel of SOLV Advocaten. SOLV Attorneys at Law. Well, that's about what I wanted to say for the introduction. Then I'm very pleased to start the presentations with someone from a very big company you probably all know. I'm sure you all know. Marco Pancini from Google Brussels.
Thank you. Thank you for having me here. For who doesn't know me, I'm Marco Pancini from the office of Google in Brussels, and I take care of internet issues, internet governance issues, freedom of expressions, and intermediary liability, which means that I'm in a kind of strange position because I'm not a privacy expert, more fundamental right expert, if we can call, you could call me expert, but more like I would call myself more a practitioner of these topics, because in my experience at Google, previously in my experience in other internet companies, I had to deal a lot with the intermediary liability and the impact that intermediary liability rules have on important fundamental rights like freedom of expression. So my point of view is slightly more practical and legal, but I hope I will be able to address this very hard question. Actually, my personal opinion is that it's dangerous to talk about balancing fundamental rights like privacy and freedom of expression for 2 reasons. First, because there is a huge debate around the 2 rights overall, and in the doctrine in between the expert, and so that's already something that has to be taken in consideration. And the second thing is that thinking about balancing, in my opinion, is putting who is in the position to do this balance, to find this balance, to make choices, and making choices about fundamental rights is a very, very dangerous thing. Our approach in general terms is not to balance. Our approach is to take in consideration these 2 fundamental rights in a very focused way, not separated, but working together in different teams that are looking after different issues that affect these fundamental rights. So let's start from privacy. I think that it's very timely to have a debate on the impact of what is happening in the world on our concept of privacy. I mean, for all of us, what happened in Paris 2 weeks ago is a wake-up call that the debate around surveillance, the debate about security is very, very complex. We thought a lot in the last year about these topics, and we come with a very strong, some very strong position. One is our efforts around encryption, for example. We believe that encryption is providing technical solution that can really make a difference in the way we as a citizen interact with the online environment. The encryption should be by default the way data are circulating in on the network and on the internet. We made a lot of investment in encryption in all our online services, and now also on Android. So by default, all the Android phone provide a full encrypted mode, which does not mean that on the other side, again here, it's not the balance, but take in consideration the big picture, which does not mean that when things like the attacks in Paris happen, there are not tools that can be taken, can be actioned by law enforcement to get information to go after suspect individuals or even people that is conducting such terrible acts. In this case, the rule of law is helping us in creating the right framework accordingly to which law enforcement, governments, and internet companies can work together in order to go after illegal activities. And this is even more than illegal activities, terrorist attacks that put life at danger, and sometimes it also kills human beings. So in this case, again, encryption as a way forward in order to protect the way citizens interact with technology, and the rule of law looking after case where there is a need of collaboration between internet service provider and law enforcement and governments to go after crimes. That's for me in terms of an example on how the debate can be framed in taking into consideration different fundamental rights as a good example. On top of that, what is also guaranteeing that the debate goes in the right direction is, in our opinion, having an important focus around transparency. We were the first company to launch the transparency report. There are a lot of companies now investing in the transparency report. We think that it is a very positive thing. You can find in the Google Transparency Report all the information around the requests that we receive from law enforcement all across the world in relation to content and user data. That's a way for all the interested parties to have a clear vision on the kind of a relationship that are ongoing between law enforcement and governments. And also, when there are debates around the surveillance issue, transparency for us was also a way to remind to everyone that the only framework in which, as I said, this collaboration and this dialogue can go on is a framework created under the rule of law, which also makes me touch for a second very quickly the surveillance issues. When we talk about the surveillance issues, we need also to take in consideration that for internet companies this was a shock. We were not collaborating with any authority in the US and around the world in any kind of surveillance issue outside the rule of law. What happened also had as a reaction from Google to be even more strong in calling for transparency. Just to give you an example, we sued the US government in order to have the possibility to publish in full transparency all the information about the requests that we were receiving. We are also we started a campaign in order to get a reform of the US law for what concern surveillance, and on top of that also we were very active in calling for equal treatment of US, European and non-European citizens in front of US courts to get redress in case of violation of any rights related to surveillance activities. All of this again to say that in practical terms, anytime there is a doubt for us that the kind of approach to fundamental rights is put at danger, we want to take action and we want to have a proactive approach towards these issues. Very last point, there are a lot of discussion around big data, which in my opinion is just a marketing term. let's call it in a different way, maybe more accurate, the way internet companies are dealing with data-driven innovation. In our opinion, defining data like the oil of this century is wrong, because oil can be put in a barrel, and barrel can be traded, and barrel can be owned, and if you own the barrel in a certain sense, it's your property. We believe that the data is more the sunlight of the internet economy, which means that does not matter the quantity of data, but what it matters is the quality of the way you process this data. Google was not the first search engine coming in the market. Before we had Yahoo. The difference was made not by the quantity of data that Google was able to collect, because at the time Yahoo was in a much better position, but was in the way our algorithms were processing this data. There are several other examples. We were the first social network in Brazil with Orkut. It took very, very few months for Facebook to enter into the market and become the number one, just because they were processing the data in a much more effective way. Say that does not mean that there should not be protection for the user. Actually, our opinion is that the user should always be in control over the way his data are collected and processed online, which for us means that when you are signing in on Google and we collect data on you, in any moment you should be able to go into your account and have full control over all these activities. Just to give you an information, every week 10 million Google users enter into the dashboard and make activities around their history of search or the data that they collect. That's, for example, is a very important number. Every user can in any moment through our tools, a tool called Takeout, take all this data and go and use another service, because we believe that we should not lock in user. User should be free to choose the service of the choice. All of this again to say user has to be in control. User needs to be in control. We want user to be in control, because for us that's the trusted relationship that we build with the user is the only way to really have an effective way to deal with them. But I don't want to steal more time. I think it's very important in such a small room and with this panel to have more a dialogue than presentation. So leave it to the next speaker.
So are there any urgent questions? No? Okay. Then we're going to move to the next speaker. I believe that's you, all right.
Okay. Thank you. Hello everyone. Thank you very much for the invite to this exquisite panel. It's actually quite interesting when we get to discuss privacy versus freedom of expression or free speech, which made a very intriguing question in my ears. And this is why I actually tried to figure out where these two rights intersect, rather which are the many differences and the balancing act and all these things. And this will be my presentation for the day. I'll start off by discussing the gift I received for Christmas, which is this. This is a fitness tracker, and I'm using it all the time. I love this. It measures how many steps I took, how long did I sleep last night, light sleep, deep sleep. It's amazing. I am pretty much doing a self-surveillance exercise, which is awesome. The problem is, I don't really know where this data is. It is in my cell phone. It is a database. It's all about me. I have access to it. I'm not sure if I have control over this. And this is the main issue. So we live in the era where we do actually like to learn more about ourselves through technology. And we've been way past the right to be left alone towards the right to be able to surf self-control, let's say, our data. The problem is that it's not just us. It's multiple people in the middle, mostly companies, mostly the so-called intermediaries and data brokers who make money out of this data. So it makes it pretty hard for you to have a right to control where your data has been or where your data will go. Now, these people have many names. They wear different hats. Sometimes they refer to themselves as mere conduits. They just transfer information, so they have no idea where this information goes. It's just 0 and 1s. It's of no use to them. And these many hats actually carry many responsibilities. Some of them, they actually act as the state's agencies, enforcing their online policies. They, on the other hand, have a personal interest to gain revenues. That summarizes the big data discussion. What is really bothering all public lawyers is the fact that there is limited accountability with transparency. We've seen transparency reports, but again, this does not answer the question of accountability. It's not the same level of accountability as the state. And as a consequence of this, this has delegitimized online actors. It has been heard time and again that they have not received any consent from the network, which is us. They treat us as passive dots. This reiterates the issue of trust. Trust is the concept that we've been listening to on and on for the past 2 years after the Snowden revelations. We keep on saying that we've lost trust. And this leads me to my first conclusion, which is where these two rights, privacy and freedom of expression, actually meet. And this is the concept of autonomy. And the real question is, can we actually maintain autonomy in times of automation, when everything is automatically done for us, for the ease of the user, as we are told? There have been many theories, and I'm trying to summarize everything in a slide, so obviously I leave more room for discussion later on. I'll just name them. There is the theory by Frank Pasquale from 2014 that we do need to establish a social understanding of the market interplay so as to be able to understand what this dark algorithm is about. There have been suggestions for the privacy by design. I'd like to stress at this point that when it comes to wearable technology and the Internet of Things, consent is not really working, and this is something that Working Party Article 29 has admitted in their recent report from September 2014. And then other solutions, such as distributed networks, peer-to-peer as a tech answer. We've heard a panel yesterday afternoon on data vaults, or how to build your own cloud, these sort of companies. And the main question is, this might be an answer to how we can underpin autonomy so as to be able to have certain level of privacy, certain level of self-determination. Could it be, on the other hand, that this would also be an underpinning rationale for freedom of expression? Do they actually meet at this point? And my main argument for this presentation is that autonomy is actually the meeting point for privacy and free speech. Now, this is where it gets a bit boring for the non-lawyers. This is where I've summarized the basic theories that go back centuries. Privacy has been expressed as the right to information through self-determination. And I quote Weston from 1967, who defined privacy as the right to determine when, how, and to what extent personal information is communicated to others, which seems very current nowadays, this sort of definition. Obviously, it implies a certain level of autonomy. On the other hand, free speech has three main underpinning rationales. The one I've chosen is the most complicated of them, which is the argument from autonomy, the argument to self-realization. This goes back to the 80s and the late 70s. Schauer, Scanlon have expressed this way better than I could ever do in this short presentation. So it seems to me that the meeting point is actually the concept of autonomy. And this brings us back to trust. And it is really cynical to be listening a lawyer talking to you about trust and how to regain trust. But actually, this could be done through re-establishing the value of autonomy online. That's the lesson that we need to take after the Snowden revelation. The trust has been lost. However, we must remember that the law in general and the internet architecture are both artifactures. They contain values, and the values are determined by us. The value that's currently missing is the value of autonomy. So the main challenge is we should regain trust by maintaining autonomy in this intermediated communications system where all these intermediaries and data brokers are ready as predators to get our information. So how do we do that? How do we go about and we solve this puzzle of regaining trust through bringing back the value of autonomy? The question is not an easy one, but the answer, I think, needs to be found in the architecture of the internet. And the architecture of the internet, and please correct me if I'm wrong because my background is really low, but the architecture of the internet is more and more being centralized. And that, to me, seems to be the main problem. It didn't used to be that way. It used to be a decentralized architecture. This is how it used to work. The two main engineering assumptions of the internet were the end-to-end concept and the modularity concept. Both of them were in place so as to be able and guarantee a decentralized architecture. And I quote here the technical standpoint by Salter in early 80s when the techies started building the internet. The main question was, where should we build the applications? Well, at the endpoints, because this is a communication system. We need to maintain the autonomy of the speaker and the listener communicating to each other. This keeps on changing. We keep on having intermediary central points through which communication passes. The legal evaluation of this has already been done in 2000 by Lessig, that this codes a new kind of neutrality, which in my ears rings as free speech. On the other hand, the technical standpoint with regard to modularity is to build a system which is actually built on many, many layers, on, as they say, quasi-autonomous subsystems. And the legal evaluation of this technical standpoint is that this architecture seems to be guaranteeing autonomy of the user because it separates the content from the communicatory mechanism. It separates the letter from the envelope. So again, we do seem to find guarantees in the net architecture with regard to autonomy, which is the meeting point for privacy and freedom of expression. But for those of you that are aware of the rivalry between the architects and the engineers, things are fantastic in theory. However, they don't work that well when we actually try to implement them online. This is the situation which has been going on for the past few years. So we've seen many internet governance forums where we try to merge law and technology, and we try to make sense of how the two could be combined together. My experience so far has been that they don't work that well together because they don't seem to realize the common values that they have. On the other hand, when we try to separate the so-called code from law, what happens is that we have balkanization of the internet, with pretty much giving in to the idea of the state not being able to protect, to give sufficient protection to the users, the consumers, or may I add, the citizens, as far as their free speech and privacy on the internet goes, and of course the limited accountability issue. And I'll leave this presentation here, and I'll open the floor to discussion later on by reiterating my main argument, which is that we should be able to identify the common values between A, the two rights that we keep on balancing, and B, between these two rights in legal terms, their legal architecture with regard to the online architecture. For me, autonomy is their shared value, and a decentralized net architecture should be regarded in legal terms as a positive right of the right to free speech online. We keep on addressing free speech as a right that needs to be restricted so as to be able and given to other rights, such as copyright or privacy. Perhaps it's the time that we should be addressing free speech in its positive manner. I'm done.
Thank you, Argyro, for this not very nice presentation. Do I pronounce your name right, Argyro? Yes. And sorry for not announcing you, which, of course, as a moderator is my task. It's my first time moderating, so take it easy on me, please. Yeah, and also thank you for shedding some light on the enormous complexity of this issue. The next speaker is also from Amsterdam, but not from the VU University, but the UvA University. His name is Bart van der Sloot. I think he's the leader of the Amsterdam Privacy Center, and a man with much knowledge and many publications.
Hi, hello. I'm going to stand here, probably. So I'm Bart van der Sloot. I'm with the Institute for Information Law at the UvA. This is the good University of Amsterdam, not the VU. This is always a battle between the two universities, of course. Yeah. I also run or coordinate the Amsterdam Privacy Platform. You have in your conference bag a call for papers for our conference in October, the Amsterdam Privacy Conference, and you should all come to visit us. And I'm now also working with like a scientific advisory board of the government of the Netherlands to advise them on big data and privacy issues, basically. And this is also what I wanted to discuss today, about maybe the underlying fundamentals of the human rights framework as such, autonomy, dignity, as the program says, as underlying values which may then be balanced against other values, either other human rights or societal interests like security. And the question is, basically, is this framework still fit for, bless you, still fit for like big data or whatever you want to call it? And the answer is no. But I will explain you why that is. So I will say something about the core fundamentals of the human rights framework right now, specifically privacy, then say something about big data, and then say something about how the Court of Human Rights approaches these types of cases and how that fits with the human rights framework. Okay? So first, this is Article 8, you all know it, of the European Convention of Human Rights. First paragraph specifies the right, then the second paragraph specifies when a state may limit the right. So if it's prescribed by law, if it's necessary in a democratic society, and if it is in the interest of a certain societal interest, such as national security. Like, this is the basics, okay. This is actually what the European Court of Human Rights takes from it. It has three core characteristics of this right. First, that it is an individual right, Article 8. Second, that it protects an individual interest. And third, that its interest is balanced against other interests. What follows from this, according to the court, is that under Article 8, only natural persons may complain. So legal persons are not allowed, in principle, there are 2 or 3 exceptions, but in principle not allowed to complain about the right to privacy, as opposed to, for example, freedom of expression, where media organizations can complain, or the freedom of religion, where churches may complain. Under Article 8, this is not allowed. And it also does not allow class actions, or actio popularis, as it calls it. Secondly, it should always be about an individual interest of the complainant. What follows from that is that it rejects in abstracto claims, which are claims about a law or a policy as such, without it being applied specifically to a natural person. It rejects a priori claims, so about damage which hasn't yet materialized, but could be. Hypothetical claims about damage which might have materialized, but about which the claimant is unsure. It rejects minimum harm, and it rejects claims about, under Article 8, about societal interests. So again, in this sense, Article 8 differs from, for example, Article 10, freedom of expression, which does protect an individual interest, freedom of expression, your own personal expression, but is also linked to societal interests, such as the search for truth through the marketplace of ideas, or the freedom of the press and the necessary in a democratic society, etc. So only individual interests, and part of it is falling off. And then third is like the balancing, so it's all relative interest, the court says, and it is balanced in concrete cases against other interests, mainly societal interests. Yeah? So with big data, this is just my quick take on it, or whatever you want to call it, these big data gathering and processing systems. It's just massive. That's not particularly about specific persons anymore. It's just gathering as much as data as you can, seeing afterwards what value it might have through statistical correlations or whatever, algorithms, and then using it mainly also on a group level by group profiles or to implement general policies. Just my big take on these kind of issues. So this specific ID that the court has developed on Article 8 is not suitable for these kind of processes. Why is that? Because often in these large data processing systems, you're simply unaware that your data has been gathered by either state secret services, by companies through tracking cookies or device fingerprinted, or even by your fellow citizens taking photographs or films. Even here in the audience, there might be someone filming me right now, which I'm not aware of. But even if and of course, if I'm not aware, I cannot submit a complaint to a court. And if I was aware, then it would be practically undoable for me as an individual to assess all the people, all the states, and all the companies who have data of me, to assess whether they do that legally, and if not, go to court. This is practical undoable in a world where so much data is gathered about each and every individual. It's also increasingly difficult to specify an individual interest in these large data gathering systems. Like London, where all these CCTV cameras are hanging. What is your specific individual interest? It is not about your specific individual interest. The NSA data gathering. I mean, of course, I might be somehow affected, but this is not the problem. It's not about specific individuals. It's about just a general societal issue. And if it's applied, these data in group profiles, it's mostly an aggregated interest. It's mostly a group interest. So it's not on the level of the individual. And then also it becomes difficult to balance these interests, because my specific individual interest is not clear in these data processing systems, but also a societal interest, for example, with the NSA. And we heard that many times by other speakers in these couple of days. It's quite unsure whether the NSA has done any good to national security Might have, but it is unsure. And this is precisely the essence of big data, is that you do not have a purpose on beforehand, but that it only afterwards you see what use it has. So both interests are increasingly abstract and vague. So it becomes undoable to balance them against each other. And also it's increasingly said that it's not relative interests anymore that are at stake. With the NSA, it's an absolute interest, namely that the state is simply abusing its power, which isn't a relative interest, it's an absolute interest. How long do I have? Oh, ooh, I should hurry up. So, but now how does the court then approach these kind of cases? It's interesting, when cases regard national security agencies, secret services, mass data gathering, it wants to assess these cases under Article 8 nevertheless. And it does so, but by leaving all the elements which I've earlier specified and the criteria it has self-set. So it does, in these cases, accept hypothetical complaints. It does accept a priori cases. It does accept in abstracto claims. For example, the famous Class case against Germany. It said the mere existence of a law or policy may violate Article 8 without any individual interest being at stake. Legal persons are allowed to complain because class actions are allowed with these types of cases. So anyone actually could bring a complaint because the personal interest is not required as a prerequisite anymore. It regards societal interest rather than individual interest, and the only thing the court does, it does not look to the individual interest, it does not look to a societal interest which benefits this data gathering. The only thing it does is assess whether the infringement is prescribed by law and what the quality of the law is. And then the question becomes, is this still a human rights framework where we're discussing? If it's not about human interest anymore, but just a societal general interest, if it's not my specific right as an individual, as a human, but it's just a general claim that everyone can bring, groups, legal persons, or whoever, and if it's not about balancing interest or assessing the quality of the policy or law as such, but only a purely legal assessment, then this is just a legal assessment of the case, and not, I would say, a purely legal or a purely human rights framework we're discussing. It's just about the state of law. So, oh, it's falling off again. Well, anyway, this is my last slide, and I have 40 seconds left. Is that perfect? So, I've discussed Article 8 as an example. But my feeling is that this is a general trend we should be aware of. That right now, all the rights are formulated on an individual level. I have a right to privacy. My personal data are being protected. But personal data means data that is identifiable. And we are increasingly going to a world where, of course, I might be identified. And of course, this is always important to tackle that problem. But we're also moving towards a situation where it's about group profiles and aggregated data, and we should look to that. Discrimination as well. I mean, of course, I might be discriminated against, but the problem is at the group level, at the group profile. So we're stuck with this basic problem of a level where we're discussing the problem.
I want to misuse my role as a chair. In the big data field, if governments and the companies do collect everything and do not select before they collect, and if they don't think about the question they want to ask to the data, you get what some say, garbage in, toxic waste out. So I think it's very important that it has a chilling effect on society, so that's the link with freedom of speech, if companies and government remain collecting all data. So that was my remark on big data and chilling effects.
Thank you, Arno. Yes. So now we see what the abuse of power actually can do in certain circumstances. So we first had Mr. Pancini, who said data is the sunlight. We see data as sunlight rather as oil. Then we had Argyro, who said, well, sunlight, she didn't say this, but sunlight is the ultimate public good, and she was talking about control over her own data and how important that is. And now Bart is actually saying, well, big data affects us all, and we cannot control this data, but because it affects us all, our individual interest of privacy cannot be defended anymore before the European Court of Human Rights, because it becomes a collective interest, which seems to be in line with civil rights that are at the core of the constitutional democratic state. Now we're going to Magda Jozwiak. Do I say that right? It's Polish. It's extremely hard. She's doing research on balancing freedom of speech and privacy online, and she's going to give her presentation now at Vrije University. Yes, and she has a microphone also. Yes,
I have a microphone.
Yes.
Okay, hi. So the topic, the very broad topic of my presentation is balancing freedom of expression and privacy online. And thank you to all the speakers. I will draw a little bit on what they already said during their presentations, so it will save me a little bit of time. So my general point and general focus of the presentation is on the process of balancing itself, because we very often say balancing of fundamental rights, balancing of privacy and freedom of expression, but we don't really focus on what this balancing consists of, what actually courts do when they balance those two rights. So that is the general focus, and my point, which I will reveal already at this stage, is that although the European Court of Human Rights developed a very good framework for balancing freedom of speech and privacy, and very broad notions of privacy and freedom of expression, and potentially it could be very well applied also to the online environment, the trend of moving from the judicial bodies to extrajudicial bodies when striking this balance makes the framework a little bit less viable. So it's not as well applicable for extrajudicial bodies as it would be by the court. So my the first issue I would like to address is what is in fact balanced. Argyro already mentioned that the freedom of expression, Article 10 of European Convention of Human Rights, it is very broad, in fact. So Article 10 says that freedom of expression consists not only in the right to hold opinions and express them, but also to receive and impart an information. So in this sense, for example, when we look at the Google Spain case, which will be a little bit my test case, and which everyone knows probably, in Google Spain, the issue was not really about right to express oneself, but about the right to receive information. And so the court on numerous occasions said that this right indeed is a constitutive part of Article 10. In fact, already in 2009, the court said that it's moving toward the broader interpretation of the notion of freedom to receive information, and it recognizes that it also comprises of the right to access the information. So according to the court, the right to freedom of expression is extremely broad, and it's based on a social function as such of freedom of expression. But the court also is inclined to recognize the social function in many different expressive activities, which make the right ever growing. So broadening the scope of the Article 10. And anyone who knows the very recent case on the naked wrangler probably knows what I'm talking about, where the expressive activity was very, very broadly stated. Next right that is balanced is right to privacy, and I will not dwell on this right because Bart already extensively addressed the issue. But the point is that also the right to privacy in the court case law is extremely broad. So it's actually allows for having privacy in public, for very broad protection of privacy of public people. So it's again, it's such a broad right that it could be in theory very well adapted to different situations that are having place online. So it's in theory, both of those rights are ever expanding and capable of being applied in the online environment. And my first conclusion at this stage is that we have two ever expanding fundamental rights, also which both confer positive obligation on the states. And in order to resolve the conflict between both of these rights, the balancing must be very contextual, because if not, we just simply have a crash of big, ever expanding to sets of different values and interests. And indeed, the court came up with a set of criteria which can be applied to address the conflict of those both rights. And in 2012, it's actually explicitly stated what are the criteria to be applied in the very famous von Hanover versus Germany second case. So the 5 criteria that were specified by the court include contribution to debate of general interest. So that is self-intuitive. It's actually one of the criteria that was applied also in Google Spain case. So what is the contribution of given information to the public, to the debate of general interest? Second would be how well known is the person concerned. That is also actually what it was mentioned in the Google case, Spain case. So the criteria is quite evident. But then, for example, prior conduct of the person concerned. So I think that's quite relevant, the criterion. For example, in the online environment, it could be court could look into whether the person actually published much of the information online, how it protected its own privacy in the previous cases, in its previous behavior. So that could be relevant. Fourth criterion is method of obtaining the information and its veracity, and fifth, content, form, and consequences of a publication. So the court, when it balances both rights at stake, it looks at all those. It does go step by step through this list, and it has very thorough analysis of circumstances surrounding the case. So it's very, very contextual. Balancing is very, very contextual. And here comes my second conclusion. Since EC, the European Court of Human Rights, provides for a detailed set of balancing criteria, it is very well suited to online context. It can be very well applied. But the thing is that such a detailed list of issues requires to be taken in case-by-case fashion. So it requires a body that has a capability to actually go in such a thorough way through the list of criteria and give a proper time and analysis to each case. And here comes the problem, because what we see now is happening. And in 2014, especially, we saw the trend of ongoing move towards attributing decision-making process to ISPs. So intermediaries were attributed certain power to make decisions in such cases of balancing. So we've seen the Google Spain case, where Google, well, against its will, was given some power to, or power obligation to decide on the balance between both rights. Then it was not concerning the privacy and freedom of expression, but freedom of expression more and copyrights. It in UPC Telekabel Wien, and then in Delphi versus Estonia, where the ECHR in principle obliged ISP to be moderator and censor before publishing certain information online, and uses comments. So in my opinion, the trend of moving from judicial bodies to extrajudicial bodies have posed different threats to the accuracy of the balancing process. And the consequence is that the very good and well-suited criteria developed by the ECHR might not be workable anymore in the environment by other bodies. And the threats, in particular, for example, could include further monopolization of the market, since proposing such a big burden on the different market players would exclude newcomers. So there's a certain barrier of entry for new entrants to the, for example, ISP market, not to look far, for example, to search engine market. Another thing is promoting the new normal, but by bigger players. So we've seen the right of freedom of expression and privacy is in a way based on certain social norms. So the court is actually enforcing certain social norms. The content, both rights are very sensitive to what is in fact considered appropriate by the society. So for example, we feel when the privacy is infringed, we know privacy infringement when we see it in a way. And moving the power from the courts, who are actually capable to pick up all those different societal interests, to market players, poses a threat of promoting certain social norms which are not as neutral would be the ones as the ones enforced by the court. And well, another argument is inevitable in this context, slippery slope argument, that the sheer amount of cases that are there would lead to just making decisions very quickly and without giving proper consideration to all the different criteria that are specified by the courts. So it is simply cheaper and easier just to censor material or just to make quick decisions without a proper consideration of different interests involved. And there are two open questions at the end. So I don't know the answer to those. Are just questions that I came up with when I was thinking about those issues. So the one question is whether it will be possible to ensure the application of ECHR balancing methodology outside the court, whether this methodology is actually well suited to be applied anywhere else. Because if so, it should be somehow maybe implemented, and if not, maybe some other methodology should be came up with by the ECHR so that it could be well adapted by the market players. And the second question, is it viable to turn around the trend of giving away the balancing of fundamental rights into the hands of new deciders? So whether ISPs should be actually given such a big power when balancing two very important fundamental rights, whether this trend could be somehow addressed, and whether there is some way to give more power back to the courts. So those are two issues, and I'm well in time, and thank you.
Okay, thank you, Magda. We already have a first.
Awesome, thank you. Thank you. So I have a question to Marco. The Google's transparency report says that there were 6,000 removal requests in the for the European privacy request for search engine removals, and I wonder, is it better to if you do a request to write in English or a local language when the article is in a local language? And by that, I also wonder how many people that evaluate these requests understand like local languages like Dutch or French.
Thanks for this question. You can use your local language, and there is people understanding local languages looking after every niche request that we are receiving, because that's one of the consequences of the decision of the court in the right to be forgotten case, so-called the right to be forgotten case. As we know, there is a debate also on the name, but in the Costeca case, that we need to look into every niche request, and this is what we are actually doing. So there is an individual that understands your language, the language of the user or the citizen that is sending to ask the question.
Thank you. Well, there's another person with a question.
Yes, this is a question for Mr. van der Sloot. I couldn't see, it's kind of the light shining on your thing. So my question, when you talk about the sort of potential inapplicability of human rights law to big data, I mean, it seems to me, I don't see what the problem is, provided that we're talking about circumstances where an individual can experience a material harm to themselves. So, you know, for example, if I'm denied a home mortgage. Well, you know, in 1975, the U.S. enacted the Home Mortgage Disclosure Act because we had a lot of racism in the loaning industry. And simply by forcing the lender to describe the reasons why the loan was denied, it went a long way towards solving that problem. If I'm stopped at the airport, if I'm put on a no-fly list, we had a federal district court decision that said you can't just put this Malaysian woman on a no-fly list for 10 years and not tell her why. So human rights, to me, seems to be working perfectly well, and there's no reason that that couldn't extend back into the algorithm that has informed an adverse decision. But it seems to me that human rights runs into problems when you're trying to apply it in an abstract scenario where, you know, it's just like, well, if in the abstract I have realized that spies spy on people, you know, I think that's where it falls apart. I just want to hear your reaction.
Yeah, thank you. So I think you're right. So if there are individual interests at stake, human rights work is perfect. But, and this is my claim, I mean, there will always be, like big data practices or group profiles will be implemented and affected to individual persons. And then we could always use the human rights framework, because then it trickles down to specific individuals. But my feeling is that we should also address like the more general and abstract problems, like the data gathering as such of the NSA, for example, or the using of profiles to make social or economic policies as such, without it directly affecting me as an individual, but just generally helping segmentization in society or stigmatization of certain groups, for example. And these kind of general and abstract problems, I feel you cannot assess under a human rights framework that is so focused on humans and human interest. So this is the only thing I wanted to say, that I feel a lot of discussions. Also yesterday I was at the big data breakfast, and the discussion always went to, well, but big data can be brought back to individual in identifiable data, and it can affect a specific person by loan, or you know, the Target example, and your daddy finding out that you might be pregnant, etc. I mean, this is always a problem. If my nude photos leak, this is always a problem, and I should always have a right to go to court. But I think this paradigm and this discourse is missing the problem. I mean, the problem, from my feeling, is here on an abstract level, and that's where we should debating the problem, and not here.
Thank you. My question would be more for Mrs. Jozwiak. Sorry. Do you think that in the European Court of Justice decision, the court actually did balance between the right of expression and the right of privacy? And if you think that the court did such a balance, to whom do you think that the court recognized such a freedom of expression? Of course, the answer would be Google and or the content editors. Might be interesting to have your views on this. Thank you.
Thank you. So it's a tricky question, because in the sense, in this judgment, there's no speech of freedom of expression whatsoever, so of freedom of speech. So the court never even mentioned freedom of expression as such, but it does mention freedom to access to information, which, as I claimed, was integrated part of freedom of expression. And in a way, the court did not address the balancing issue so clearly as the ECHR does in its decision. So it's also a little bit like undercover balancing, but I have a feeling that there was some balancing going on. And actually the court, it's in one of the passage of the judgment, clearly stated that as a general principle, the interest of individuals whose data were exposed would override the interest of access to information. So there was some kind of balancing, and of course the court mentioned two criteria I also had on my list, on the criteria list that is applied by the ECHR. So there was some balancing, but it is a shame that the court did not really face this issue heads on. So in a way, it didn't really, it did some undercover balancing. It was not very clear about it. And it didn't explain very well how such a balancing is to be made in some later cases. So I think there was balancing done, in fact, but not very well. The court was not very honest in this balancing exercise that it did.
Thank you. Well, my question refers to the right to reputation, which is also part of the right to private life. I would like to ask you whether individual can be the ultimate decisive authority for his or her reputation online. To all of the panelists.
Directed to one person.
Maybe to Miss Jozwiak, because yes, I'm sorry, because she cited Van Hanover and this criteria for deciding. But what if the person is not a public person?
Actually, it's Jozwiak, so that's how it's correctly pronounced.
Sorry.
No, it's. But I'm not sure if I understood the question well. So it's whether the individual itself can be the ultimate authority for establishing its own reputation. Well, but I don't think that individual is ever the decisive authority as such, because reputation is in a way a social value. That's why it's quite tricky to have it contained in the right to privacy, which normally should be about the private sphere, while reputation in the common sense would be about how others see it. So it's directed to this outer sphere. But it's true that right to reputation was always what has been recognized as a constitutive part of the right to privacy. But I don't think an individual could be the one who decides how it's seen. So we have our persona, and we have our public persona, and we can shape it in a way. But at the moment when there's some inherently valuable information about the persona, no matter how much we want to protect it, and there's some kind of contribution to public debate according to the criteria, I don't think a person should be able to shape it as it wants. It has to be somehow verified by the society as it wants to see the person. I don't know if anyone wants to address the issue.
Yeah, I think it's just a mistake the court made to allow claims for reputation on the right to privacy. I mean, it's left explicitly out of Article 8 by the Convention drafters and put in the second paragraph of Article 10. So it's a limitation clause for the state to legitimately limit the right to freedom of expression. And this was a deliberate choice not to make it a subjective right of the individual. And I think this is the core of the problem.
So I have a question to Ms. Jozwiak. So
we'll get there.
I'm Polish, so it's easier. So the court, in a way, when it was balancing the interest, he said that in principle the right to privacy prevails over the right of users to know about the person. And so in a way it suggested that in principle the search engine should delete the link unless there are some other important reasons. And in a way this is in line with the intermediary service provider's position. So do you think that that's correct to by default be very favorable to request for removal, and how does it influence the freedom of expression on the other hand?
Well, thank you. So I think that's the entire problem, that the court kind of pre-decided the balance and did not get involved in much context of the balancing itself. So I'm not sure it's good to predetermine the result as like that. I think it should be more run on a case-by-case basis. So I think that's where the mistake of the court was, and in such a important and notorious decision, and the court must have known that it will raise so many doubts. It should have given some little bit more or guidance on how to strike the balance. So I do not think it's one can say in every single case the right of data subjects should prevail over the right of information of the others, and it is just so contextual. It's very hard to determine it like that.
Okay, thank you. As a moderator, I also have the responsibility to balance the questions that go to the different panelists. So I have a question that involves Marco and Argyro. Argyro, you have a live logging device and you're talking about control of your data, and I was wondering if Google would design a place where you could log actually your live logging data, where you could store it, how should it look for you for you to trust Google to actually store your data there? Is that
Thank you. Well, actually, this tears apart my whole argument about decentralization.
That's true. Yeah, okay. Well, maybe that's an answer too.
So first of all, there have been such suggestions by lots of people in the industry, the so-called data vaults, or build your own cloud. That's another one, which actually I find quite intriguing, because the main problem is not collection. It might not even be processing data. It's actually storage, where this is stored, which cloud. We don't really have this sort of information. So this is where decentralization fits into the picture. I'm afraid that as it stands, and Google is just an example, there are many other examples, what I would like to try and avoid in all these technical solutions put forth is really a handful of players dealing with these sort of issues. I'm not sure if I've answered
that is a good answer. Still for Marco, yeah.
Very quickly, a couple of things. First, I want to clarify that I avoided to touch the right to be forgotten case in my introduction, because I didn't want to. I think the jury is out on this, and what is very useful is to have a debate in the society with all the stakeholders and extract values from this debate in order to give further guidance to Google on how to implement the decision of the court. Just to make it clear that I was not trying to avoid the topic, but I think it's very interesting to have indeed this kind of discussion in the panel. On your specific question, I totally agree that there is no point in thinking on health, e-health, and this kind of opportunities, not only for individuals but also for state. Okay? Just for you to imagine how what could represent for governments to rely on technology in order to make the health system more efficient. I say that I think the solution is not centralization, is not to think about a specific single point of contact for collecting all your health data, but the solution is to really, as a society and in policy-making activity, draw some kind of principle on how this kind of collection and the consent and the control over this data has to be carried out, because we as internet service provider, as a company that is providing services online, we don't want to force user to a specific behavior or to collect data without the user consent, because that would be just not the right way to approach to the user and create the level of trust that the user needs to have towards the industry, also the government, in order to collect this kind of data. On top of that, it's important to have this discussion because we all see that this could be extremely important. Just to say, to mention something, all the innovation that are coming from Google X and other biotech companies in terms of thinking how to overcome the limits that we have today in terms of curing very, very, very important disease is an opportunity there. There is an opportunity there that needs to be taken in consideration.
Yes, I have a question for Argyro as well. You talked about the decentralization and modularity as the ways to implement, to embed autonomy in the internet architecture. I'm interested not in the technical feature or how to do this from the code perspective, but from the pure legal perspective, there's a word that maybe was missing in your presentation, which is responsibility. Because embedding autonomy via modularity and decentralization means redistributing and maybe also redefining responsibilities, legal and non-legal responsibilities within the architecture of the net. And in this respect, maybe I have a related question to Marco about it seems to me a kind of a voluntary implementation of the rule of law by a private company, which is a very interesting concept. But the problem is on the guarantee. So as this is not the rule of law is normal under the scrutiny of a court, of a higher court. When it's implemented in a private way, there should be some other ways of guarantees. Could be transparency, for instance. An answer to this? Thank you.
Just a very brief comment. I fully agree with you. Responsibility is a key issue because ultimately what's been going on for the past 10 years or so is that we are redrafting constitutional rights online with the help of the techies. And sometimes it's actually quite frankly disturbing when you see lawyers and techies not being able to understand each other because they speak different languages. So yes, there is a shared responsibility in this domain. I fully agree with you.
On the question in relation to the private application, the application of the private enforcement of rules, I think that when we heard and when we have seen the decision of the court, we were facing the dilemma of, as you say, this is a court and what are the consequences. I think we made the right decision in trying to extract as much as we could principle out of this decision and carry out an application of them, because it was the expectation of the court, of all the different stakeholders. But I also agree with you that it's very, very important that the forthcoming GDPR, so the regulation around data protection in Europe, will shed a light on the right to be forgotten, the right to deletion, let's call it as you prefer. But so I agree with you that it's very, very important to have some clarity coming from the rule of law on this specific topic.
Okay, are there more questions? Are there maybe questions that one of the panelists wants to ask to another one of the panelists? No? Okay. Then I'll just ask a question. I think I have one. Let me see. Bart, do you think, because you say that big data collection does not focus on the individual, and maybe you already had the question, but I'm just very stubborn. But big data collection, it focuses on us all, and it does focus on collection of personal data. Is that not a sufficient argument to also let the right to privacy be relevant? I see the point that you make, that the discussion should be actually held on a more abstract level, but does that discussion over there exclude the relevance of the right to privacy when it comes to big data collection?
I think it does in a way. So you could always link it back to the individual, say at the starting point of data gathering that a lot of data are still identifiable, but it might be in a split second, might be aggregated or anonymized or whatever. And then something happens, and then you could go back and at the moment it affects a specific person. So these are the 2 points you could take to link it back to individual interest or individual rights. But my feeling is that the whole part in the middle is of utmost importance, and that is where we should look. And also there are policies which can be quite difficult to relate to specific individuals or direct effects. Just general zip code policies based on zip codes, for example. I mean, there's not specific personal information in that. It doesn't really affect me as an individual. I mean, I can see why a state or a company wants to differentiate between zip codes or whatever general criterion. It's not a problem. What is the problem is that we go to, presumably, and no one knows, but presumably to a world where this is the basic. And so it might be that you're just predetermined by your zip code or another characteristic. And so for me this is the problem. And also I spoke to some people, for example, in healthcare. And they now know, for example, that in 20 years' time in city X there will be much, say, fat people. And so what they want to do is redesign the city so that people are inclined to walk more.
A lot of stairways.
Stairways
Yes.
being put in front of buildings and elevators to the back, etc. I mean, this is not a specific, it's not, wow, I'm harmed as an individual because I have to take the stairs instead of the elevator. But it is, in a general way, an issue to think about, that if all these general policies steer your individual choices without you being conscious of it all the time, that we should think about how this affects autonomy and a society as such.
Very interesting. Thank you.
Hi, this question's for Marco. Regarding individuals' free speech and privacy, how are the latest moves by UK and French officials to try to, either conduct surveillance or interception, or, requiring that companies in Germany and France take information off the internet? How do you see that all playing out right now across Europe?
I think that's a confirmation for me that what we really need to have is a clear enforcement of the rule of law, even in an environment where encryption is becoming by default, and in our opinion this should be the case, the solution to protect user data against surveillance. I think having clear rules in terms of how law enforcement and internet service provider can work together to in very high level investigation, on terrorism investigation, on protecting citizens against crime, that's the real solution. I think there was I think it's healthy to have this debate. I think it's healthy to have even a dialogue ongoing on this specific issue with governments. I think the solution is there. We probably thinking about different new laws to address this kind of issues in this emotional moment does not take in consideration that there are already a lot of tools that can be activated in order to achieve this result, and we look forward actually to have a dialogue with the governments, with the French government, with the UK governments, with the European Commission on how to activate this tool that already exists under the rule of law on one side, but on the other side also working together on some strong counter-narrative initiatives, because the problem, as we know, is not just on the internet, but it's also in the society, and the internet can actually help to have a more healthy debate around radicalization, around these societal issues.
It is time. I would like to thank you all, and I would like to have a big round of applause for all the panelists. Thank you, and I wish you a good conference for the rest of the day.